We continue to follow the latest news out of Colorado, where last week's deadly shooting rampage, a gunman entered the Aurora, Colorado movie theater, as you remember, firing a shot after shot, killing 12 people and injuring another 58. Yesterday, the accused gunman, James Holmes, had his first court hearing. And to weigh in, we welcome attorney David Aylor. Counselor, thank you so much for being here. Now, you watched these proceedings. What were your initial impressions of the suspect?
Well, I mean, it looked like you seemed to be somewhat shell-shocked. I wasn't surprised that there wasn't, a lot of emotion and obviously a lot of interaction between him and his counsel. I'm sure that my guess would be that prior to, the actual hearing, he was advised by his counsel that there would obviously be tons of cameras and tons of folks watching. So the least amount of emotion and just really reaction at all that he could probably put in, the better. So I would probably venture to guess that, in fact, that him not making a lot of reaction and things like that was something that he was probably advised.
Right. Now you deal with clients not in this similar situation, but that have been accused of crimes before. This gentleman had to wait 4 days before going back into the courtroom. What happens in jail for those prisoners, those accused suspects, for those 4 days while they're waiting that bond hearing?
Well, every situation is different. In this specific situation, he was in solitary confinement, which, for people that don't understand what that means, is it means he was set away from everyone else. Usually when you go into jail, you're put in just the general population. So there could be everybody that was in there, from anything from, a check fraud situation to, even violent crimes. But for his specific situation, due to security reasons and various other things, they put him by himself. So really, outside of his meals and maybe being able to go outside for small amounts of times, I don't know what all the specifics were, he was solely by himself for those 4 days. So I'm sure that may have also caused, it looked like a lot of people were commenting, it looked like he was really tired, sort of out of it. It could be obviously from that.
And that would just cause the kind of disorientation that we saw yesterday,
right,
perhaps?
Exactly.
Okay. We also want to get to the issue of competency, because a lot of people are saying this gentleman has mental illness, though some are still saying that this attack was pre-planned with all of the bomb-making materials in his apartment. What's your legal representation of this? Do you think he's competent to stand trial?
Well, it'll be interesting to see what they say on the long run. I think you make a good point there that it seemed like a lot of these things that he was doing were pre-planned, related to what was in his apartment. Obviously, the effort and the time that it took to do what he did in regards to what actually happened there at the movie theater. And what people have to understand is, just because someone may be crazy per se or mentally ill, that doesn't mean that that's an ultimate defense to the crimes they commit. If they know the difference between right and wrong, they're still guilty of that crime for that reason. Sometimes people get a little bit blurred into what they believe, oh, that person's crazy, therefore they're really not at fault. And that's just not the way that it works.
Right. So do you think that he is competent to stand trial? And what is that threshold of competency?
Well, I think that it'll come down to a number of things that they'll have to put him through a battery of tests. It's too early to tell at this point, but obviously he's a very intelligent individual per what we've heard on the news. And he's done a lot of pre-planning, at least to some degree, from what he did within his apartment and also to get into the movie theater and do what he did there. Ultimately it'll determine whether or not he knew what he was doing, and if he knew what he was doing was right or wrong. And if they can show that he knew what he was doing was right or wrong, and he chose to do the wrong, then he's competent.
The prosecutor said that there's no such thing as a slam dunk case, even though they have the man. Obviously the evidence is mounting up. What would you do on both the prosecution side and the defense side?
Well, right now they're both doing, the smart thing, and they're not making a lot of comments about it. You can't jump to conclusions, and as an attorney, no matter what you're doing, whether you're the prosecutor or the defense attorney, you can't let your emotions get involved, and particularly you can't, play to the media. I think you saw that, for instance, like the Duke lacrosse case, where that prosecutor seemed to just get over his head into the emotions and really the fight of the case, and ultimately there were some ethical issues there, and he lost his license. As a prosecutor, no matter how hard and how tenacious you want to go, you still have to follow within the ethics of the law. As a defense attorney, no matter how difficult it may be, you have to defend your client to the best of your ability, or you shouldn't be that person's defense attorney. So it may be tough for people to see someone sitting beside an individual like this person who's been accused of these horrid crimes, but you have to understand that no matter who's accused of anything, they have the right to defense counsel.
Right. A lot more on this case to come, and attorney David Aylor will be there to give us that legal expertise. We appreciate it, Counselor.
Thanks for having me.
All right, and we'll be right back with more Low Country Live in just a moment. Stay with us.